Welcome, everybody, to the case updates, the key case updates for the month of April 2026, presented by Veritas Workplace Investigations. This month, George, it seems that we have some slim pickings. There are not that many cases published by the courts during the month of April. I don't know why, but it seems like that's the way it's happening this month. So with that, I am going to ask you to please discuss the case of Paknad versus Superior Court.
Great. Yeah. Paknad versus Superior Court involves a workplace investigation. The company hired an attorney to do the investigation. The plaintiff, at the time the employee, who later became the plaintiff, made various claims, including sexual harassment, gender discrimination, and retaliation. And when the employee subsequently sued, the company touted their thorough and independent investigation report. And so the plaintiff, of course, wanted a copy of the report. And the employer leaned on attorney-client privilege and work product and refused to produce the report. Plaintiff filed a motion to compel, and the trial court ordered the materials produced, subject to an in-camera review, meaning some of the report might have attorney-client privilege, some of it might have lost its attorney-client privilege. So the defendant produced some heavily redacted set of documents, and the court allowed the redactions. So the plaintiff appealed to the Court of Appeal, believing that they should get more than a very heavily redacted document. And the defendant, of course, believed that the work product doctrine applied. However, the Court of Appeal found that the defendant had put much of their information at issue. By claiming that they had conducted a thorough investigation into plaintiff's claims, they brought the quality and the scope of the investigation into play. And so what ended up happening after a couple of appeals and some writs and stuff is that the Court of Appeal ordered the trial court to review the unredacted report and investigation materials to determine which information was relevant to the scope and the adequacy of the investigation. So basically, the Court of Appeal said, we're going to give you the rule, you do the work, but here's the way you look at this, and what is attorney-client privilege and what is not attorney-client privilege, and what lost its privilege when they voluntarily said, we had a thorough and independent investigation, and so they lost some of their work product and attorney-client privilege by putting their investigation at issue.
George, if I understand it, the Court of Appeal did not draw the line of what was protected and what was lost under the privilege of the attorney-client relationship, right?
Correct.
Now, the trial court is supposed to do that. We may find out, we may not find out, but I think there's a lesson here. What is the lesson for employers?
The lesson for employers is, if you want to use a workplace investigation to defend a lawsuit, be careful. You're going to lose your attorney-client privilege probably in a broader way than you hope for. And I imagine this is because one of the causes of action was failure to prevent, right? And the employer saying, we didn't fail to prevent. Look at this amazing investigation that we did. And so the plaintiff's like, oh yeah, let me see it. So the lesson is, if you want to use it, be prepared to lose privilege.
And is there a lesson for employees?
Absolutely, yeah. Ask for everything, and know that you can pierce the attorney-client privilege and the work product doctrine if they put it at issue. Now, bear in mind that the Court of Appeal and even the trial court were trying to do it right. They were trying to say there's a scope, right? Every single word in the report is not necessarily discoverable. Some of it still maintains privilege. But what is the scope of what they put at issue? What they put at issue was the thoroughness of the report, the independence of their report, the veracity of their report. Everything that they put at issue as a defense to the suit loses its privilege.
And the reason why I ask you this question, George, is because it seems to me that the decision to use an investigation report as a sword to say that that defeats the cause of action, logically, they would have expected that if you're going to use it as a sword to try to beat a claim, well, you have to produce it. Makes sense. How can you use
Right.
something that you are hiding? How can you claim that something happened when you're not showing it, right? On the other side, if you're going to use it as a shield to prevent these types of claims, then do you need confidentiality? Do you need privilege? Do you need to be for the document to remain confidential under the privilege? Maybe. So this is an interesting point. It's just it just doesn't make sense to me that the employer tried to use it to try to bar a claim without producing it. And I think that the lesson here is that the courts, at least this Court of Appeal, is saying, be careful, because if you put it at issue, you may lose your privilege, which I think is saying loud and clear to the investigators also, be careful what you put in your report, because if you are going to lose the privilege, make sure that you know what you're doing if you're hired as an investigator who was also acting as an attorney. And that's where the protection triggers, right? The protection of the report only applies if the attorney is working as an attorney doing investigation work. So
Right.
this is giving clarity, some clarity as to what is protected and what is not. But at least I'm hopeful that the Court of Appeal recognized that some of portion of the report may still be redacted. So it was not a total loss for the investigator and the employer, right?
They did recognize that, and the fight really ended up not being was any privilege waived. The answer to that was yes, and everybody agreed the answer was yes. The only question was how much.
And from heavily redacted to we don't know how much. So be careful, employers, employees, know what to ask for, insist, and if necessary, point to this case. Great. Thank you. Now, let me change subjects dramatically, because now I want to talk about a case that, by all accounts, may not happen to many of us, but I think is really interesting. And we were talking about it off before making the recording. It sounds really, really interesting. This is the Hensley, my pronunciation, versus Fluor Daniels or Fluor Corp. And this is a case that, just to summarize it briefly, the government of the United States hired a federal contractor to do some work in Afghanistan as part of the reconstruction of the country. And as part of that, this federal contractor hired people from the US, but it also hired locals. And an unfortunate event happened. One of the locals committed an act of terrorism and actually killed some of the contractors and injured others, people in Afghanistan. Some were US-based employees. So one of the affected employees filed a lawsuit against the federal contractor for the negligence in recruiting somebody who caused a terrorist act and caused damages. And the defense of the employer was to say that they, because they were doing government work, were protected by the laws that shield the government from being sued. And that went to the court, and the court concluded at the end of it that even though they were being hired by the United States government, they were not the United States government. And when you are not the government, you cannot claim the protection that the government has. So this case is going to continue, and this member of the Army is going to be able to file and continue the lawsuit against the Fluor Corporation, which is a pretty big contractor. What do you think, George?
Very interesting case. Touched home a little bit. My daughter was deployed in Afghanistan twice, and she's also in the Army, and she was at a forward operating base. So, of course, I found this very intriguing and interesting. The court did parse it in this way, meaning the conduct of the contractor of Fluor Corp was neither ordered by the federal government nor authorized by the federal government. So what the court is saying is there may be situations where a government contractor acting on orders by the federal government may enjoy the immunity or the preemption that the government enjoys because they were acting on behalf of the government. But in this situation, they hired somebody, negligently hired them, negligently retained them, and then they carried out a suicide bomb attack, which killed a number of people and injured the plaintiff in this case. So it's not just a blanket statement that federal contractors are open season, but it has to be under a certain circumstance when they're doing something on their own and not being controlled by the government.
I agree with that rule. It just seems interesting to me that if you are asking me to perform work in country overseas, and you are asking me as part of the bid to hire locals, or you're asking me to hire locals. So was this authorized by the government? Was it required by the government? So that distinction, it seems interesting to me as a matter of justice. It's unfair that somebody died and nobody's going to be responsible for it. But on the other hand, when the government gives a contract and they ask you to hire people, aren't they instructing you to do that if the cause of action is based on negligent hiring?
I think what the court is saying is, sure, you were instructed to hire people, but you weren't instructed to hire this person. So this was factual, not legal, that they made the contractor made the specific decision to recruit and hire and retain this particular person, and the government had no supervision over that particular set of acts.
And that's why the negligence may continue. For most of us, this case is not going to change our practice. It just seemed to me that it's really interesting because, once again, if somebody's not pushing it and trying to change the law is not going to change. So I think that the message here is that by looking at good facts, you may push the court to change the law, even if the law seems to be against you. And that's the message. That's what I took from this case, George. I hear you. You are an Army dad. You have a different take than me. But so what do you think? Should we just push it when we have good facts?
From the plaintiff's side, if I have good facts, yes, I'm going to push it. There's always a legal theory, and I love creative legal theories. I used the family code one time as the public policy to support a wrongful termination cause of action. So you're always going to find legal creativity applauded by me.
And I approve. Now let me change the subject now, George, and bring you back from Afghanistan to California in something that we all deal with every day and twice on Sunday, which has to do with arbitration agreements. Oh boy, one more month, many arbitration cases. But you're going to discuss just one of the many that came down the pike on arbitration, and I think that's the Stoker versus Blue Origin LLC case. George, what happened there?
Correct. This has a lot of the elements that we're all familiar with. And the more of these cases that I break down and the more times that I fight these from the plaintiff's side and from the plaintiff's point of view, I find that the same set of facts get interpreted differently by different courts. So this only reinforces my belief that the primary question in a motion to compel arbitration is, who is your judge? That being said, this court hit on some of our familiar favorites that an arbitration agreement in the employment context is typically a contract of adhesion and thus has at least a low level of procedural unconscionability. The question obviously comes down next to substantive unconscionability. And there's a pretty good case that came out a couple years ago called Cook versus USC. And Stoker versus Blue Origin echoes this case a little bit. One of the unconscionable terms was that the agreement was overbroad, meaning it did not limit it to claims arising out of employment. It was unlimited. It could have been any type of claim whatsoever, or was it limited in time? So overbroad. Secondly, the agreement was applicable to claims likely to be brought by plaintiff, while excluding claims likely to be brought by defendant. What happened in this particular agreement is that the defendant carved out for them relief for trade secrets and confidentiality in court. Third was that it waived the right to a jury trial in court. Now, that doesn't mean that when an arbitration agreement sends you to arbitration and also happens to mention that that means you don't get a jury. What they're saying here is if part of the claim remains in court, to waive a jury trial, meaning that you're forced into a bench trial, that's an unconscionable term. And lastly, it waived the right to pursue claims on a class of representative basis. Specifically here, it had a pretty harsh PAGA waiver. Here, the court refused to sever the offending terms because they believed they would have had to write additional terms to the agreement, sever important parts of the agreement, and change the nature and scope of the agreement itself. And they also said something interesting that's been said before, but they declined to incentivize one-sided agreement by simply severing unconscionable terms. It's a really interesting thing to say. It says, hey, employers, if we sever unconscionable terms from arbitration agreements and then enforce them anyways, that gives you a green light to write very unfavorable arbitration agreements, at least unfavorable to the employee, knowing that you have this backstop of whatever judge I get is going to cross out the stuff he doesn't like, but I still get arbitration. And if he forgets a couple, I even get those unconscionable terms in my arbitration process. So again, these are some familiar themes that we've seen before. And this particular case clearly falls in the camp of probably a judge who leans against employer arbitration. I've seen cases with very similar facts go the other way. But just a reminder, especially to plaintiffs, I challenge every single arbitration agreement because there's always something in there. And, maybe get to know your judges. There's a service called tentativerulings.org. And I have a case right now in Santa Barbara, Santa Maria, where I was able to get the tentative rulings from the judge that I'm in front of. And he had a fairly even record of granting and denying motions to compel arbitration. And so I feel like I have I've got a fighting chance in that particular situation.
Going back to the court's decision in this Blue Origin case, George, do you agree with what the court did here?
100%.
Would you feel
Absolutely.
different if you were the attorney for Blue Origin?
Well, the first thing I'd do is I'd go to Blue Origin and say, you can't write agreements like this. You can't carve out your right to be in court for trade secrets and confidentiality and force the employee into arbitration for every single claim they ever bring. You need to restrict this to claims arising from employment and to limit it as to the natural statute of limitations from claims that arise from employment. I would ask my client, who is the employer, tighten up their agreement.
And the reason why I ask you that question is because it seems to me that this may be one of those cases where an employer has a policy and they just let it sit and time goes by and nobody looks at it until it becomes an issue. So now that the courts are every month publishing multiple cases going in either direction, for and against, but it's pretty clear by now that mutuality is a requirement, right? So why would you allow for a section of the agreement to say, accept this, accept that, right?
It was probably an old agreement, or sometimes what you see is Blue Origin may have, and I think they do have a presence in other states where they don't have the same issues that California has. So really, I wouldn't say it's negligent lawyering, but I would say someone who represents a company, first thing they should do, in addition to making sure the handbook is up to date, is say, show me your arbitration agreement.
And as to the lack of mutuality, I kind of agree with the court because it should be clear law now. But I do have an issue with the waiver of the right to a jury trial because although I heard you when you said that if you waive your right to go to court, if you're not in court, you don't get a jury. Okay. It's different from saying if you remain in court, you don't get a jury. It's not the same thing, right? You cannot ask somebody to waive their right to a jury trial if they are in court.
Correct.
Public policy. But you can force an employee to give up the right to go to court, full stop. And if you're not in court, you will never get a jury.
Right. It's
So
inclusive.
this splitting of the hairs, I'm a little bit concerned because not only that statement, also the statement about it is unconscionable to ask people to give up the right to a representative action. Let us be honest. One of the main reasons why employers have an arbitration agreement is to avoid a PAGA case because arbitration has become so expensive that sometimes it's cheaper to stay in court than to pay the arbitration fees. So why on earth would an employer do an arbitration agreement? And it's typically to avoid somebody filing a PAGA claim and just on some theories bring very expensive litigation. At least the law is that the individual claim goes to arbitration first, the representative action is stayed, and that's the state of affairs as of April 2026. Here we are in May. So in that sense, I'm concerned that the court said like, well, you can do that. You cannot ask people to waive their right to representative actions. And the compact is like, yes, we can. because courts enforce it every month, right?
Absolutely, but this goes back to my comment that if you were in front of a different judge, he'd say the exact opposite, and he'd have case law to support it. There's case law to support both sides of these arguments.
And some courts do use the pencil to carve out. And this court said that they are not going to do that. So it was a court of appeal.
Mm-hmm.
So,
Absolutely.
so there's a learning experience there for all of us. Well, thank you, George. And now let me, as I mentioned, there are not that many cases this month, but I do want to bring a case to us and the group that deals with a civil case that is not an employment case, but I think it's very important. It's the case of Detrick v. Shimada. And this is a Court of Appeals decision on a case that dealt with an attorney actually being sued, and the attorney suing the client, former client that sued the attorney. So you have the former client suing the attorney and the attorney suing the former client. But the point is that there was pending before the court a motion for summary judgment that the court granted. But as part of evaluating the motion for summary judgment, there was an objection as to a declaration, and the declaration was prepared by somebody who doesn't speak, write, or read English. So a non-English speaker gave a declaration in English, and the objection of the party against the declaration was that it did not have a statement, that the declarant either used an interpreter and the declaration was read to the person, so the person understood what they were signing. That was missing from the declaration, so it should have not been allowed as evidence. The trial court admitted the declaration, and based on the declaration, granted summary judgment. It goes to the Court of Appeals, and the Court of Appeals then overturned the trial court, saying that a non-English speaker who gives a declaration in English, that declaration must have a statement that the declaration was read to the person and they understood what they were signing. This is interesting to me for two reasons, George. Number one, it's not in the law, really. There's no law that says that your declaration has to have that statement. So this is new. But more importantly, there are so many non-English speakers in court that regularly, in my experience, file declarations in English that clearly shows that somebody gave them to them and they just sign off on it without really understanding what was happening. So at least there is a Court of Appeal saying, wait a minute, is this real evidence? And in the case of Detrick versus Shimada, it's going back. What do you think, George?
Yeah, absolutely. A court has the right to require competent evidence. And that's the situation here where it had to do with reading, writing, and speaking English. But it's a comment across the board that evidence has to be competent. I mean, I think almost 99% of individuals and clients' declarations are originally written by the lawyer, right? But then, of course, the client is able to review it and able to correct factual mistakes. But if you don't read or write English, you can't even correct factual mistakes, much less make it your own. So I understand it, that a court can require competent evidence. I don't think it just applies to speaking this language or speaking that language. I would never submit the declaration of a non-English speaker without the declaration of a translator, that they reviewed it with the person and that the person understood what was said. I'm not sure what happened here. We had a former client with a former attorney suing each other up one side and down the other, malicious prosecution, a malpractice suit. So there was some real vitriol going on here. And I imagine that the former client who didn't speak English, somebody had to write that declaration, right? And how would they know what to write unless they spoke to him? But the court just can't accept that. They just can't assume that. They have to deal with competent evidence.
In your experience, George, have you seen declarations from people that you know they're not English speakers?
Of course, I've had a bunch of non-English speaking clients, but I have translators. I speak enough Spanish to be dangerous, but I also have translators. If I'm going to put something in front of a court, absolutely, there's going to be that extra declaration page from the translator.
I meant to ask you on the other side, have you seen declarations on the other side that you know that the person was not a competent witness?
I have a recent case against an oil company, and a bunch of oil company executives wrote some very convenient declarations that were certainly prepared by the attorney, but they spoke English. I wasn't going to challenge that.
At least on whether they were a competent witness, you may attack the allegations, right? The facts. But the reason why I mentioned that is because sometimes it happens, and it seems to me that some courts look the other way, and at least this Court of Appeal is making a point that it is important to make sure that if you want to prove facts with a declaration, and the person is a non-English speaker, which is common in California, then you have to make sure that at least you tell the court that the person, somebody told them in their native language what they were signing.
We get a case like this and we see the high level facts, and we don't know every single thing that happened during the case, right? So there's stuff, there was a bunch of stuff flying back and forth. So sometimes there's just some little detail to some case. I think of the famous McDonald's case where the elderly woman spilled coffee on her lap, and I ended up learning later that that what people then thought was an outrageous judgment was really the result of attorney neglect on the part of McDonald's, where they treated it as if it was not a serious case, and they ignored stuff and missed deadlines and just did a whole bunch of stuff that really irritated the court and eventually the jury. And that played into the large verdict that everybody was aghast at back in the day, one of the first $1 million verdicts. And so I think there's always something in cases. And in the case where we have a former client and a former attorney suing each other for malpractice and malicious prosecution, that was a lot of mud flying.
And in the McDonald case, also the person's skin was burned. It was not just scalding hot. It was literally a burn that required medical attention. So it's not like, oh, I spilled coffee, give me millions. Is I need to have surgery. So
Yeah,
the coffee was at a dangerous temperature, right?
facts stipulated, but there's always extra flavor when you hear about what went down on a day-to-day basis.
So I guess the message to all of us is just don't mind the headlines, take a deeper dive. That's why I brought this case from the civil area, not an employment case. But I think it's a message for all of us in the employment arena to be mindful of the evidence to make sure it's good. And in the case of declarations, now we have an extra item for the checklist.
Mm-hmm.
So that's my take on it. George, is there anything else you want to add?
No, I think we're good for the month. We have my usual First Amendment cases that we don't talk about, but we'll deal with
Maybe
that.
you should make it a section on First Amendment and political cases separate from the employment was. So looking forward to that. So with that, thank you, George, for everything that you have done for this. And thank you, everybody, for watching. If you make it to here, congratulations to the end of it. And we'll see you next month.